Well, god damn it, we're back. Get my chair in position, which I can't. And I don't feel like getting up. Hello. Glasses are gone because let me tell you something. I get out of this live, I transition very quickly. So we're back. Mostly because I don't have time to cover this first thing tomorrow. I was shutting down, checked my email, docket update. Hi, beautiful. This is not going to be very long. We did. We did. Here we are with our own little sequel.
High five. I'm bulletproof.
I thought I would be chill. I'm telling you, I could flip a switch. Basically, as soon as I turned that light off, I'm like, I'm done. And then I was starting to fold everything up, and nope, I'm not done. No, I'm not. So, this is the Barry White Trust versus Rodney O. It used to be versus Rodney O and Joe Cooley. They settled with Joe Cooley a couple months ago. Good night, beautiful. Get some good rest. Get some good rest. So this is the first lawsuit. Oh, don't worry, Goldie. We're not going to be here very long. I appreciate everybody who can join. Hit the like, who can join, hit the like button. This is for the replay gang. Like I said, I don't have time to get into this tomorrow morning. So I'm not sure if I'm going to have a live tomorrow. So I said, okay, okay, let's do it now. I had stopped paying attention to the alerts on my phone because Oscar has been very active and setting off my phone alerts. So I just tuned them out. But this came in actually about an hour ago. So again, this is the first lawsuit. This is the Barry White Trust versus, it says Cooley, but again, they settled with Cooley. Case names stay the same, even if parties leave the actual litigation. So this is a settlement with Rodney O. Okay. And this letter, like I said, just came on to the docket about an hour ago, and it is submitted by the Barry White Family Trust to the judge. Dear Judge Coate, the parties jointly write to notify the court that the parties have reached a settlement agreement resolving all claims in this action. In light of the foregoing, and to conserve judicial resources and the resources of the parties as they finalize their settlement, the parties respectfully request that all pre-trial dates be vacated and that the court set a status conference regarding settlement for 60 days from the date hereof if dismissal with prejudice is not filed within 30 days. So what that means is we have reached a preliminary settlement. We're hammering out the final details. If that comes to pass, the Barry White Family Trust should be submitting a motion to withdraw with prejudice, meaning the case does not get filed again within the next 30 days. If that does not come onto the docket in the next 30 days, then we would like a status conference with the judge 30 days after that. And then they go through kind of what they've asked for in the past in terms of asking for a continuance, because that's what this is. When it hit the docket, it said continuance, not settlement. So the second paragraph is just explaining where they have made requests in the past that are either a continuance or an extension of time, etc. So that's all the second paragraph is. So they have reached a settlement agreement. Barring any complications, that should result in this case being withdrawn with prejudice, meaning it cannot be filed again. If for some reason it doesn't happen, they'll be back in court in 60 days if the judge approves this request. So there are no attachments to this, okay? We don't know what the settlement is, but we do, because of all of the things we went through last night, have a potential indicator of the things that it could include. Okay? This is from August 9, 2024. And this was one of the many things in the 331 pages that we skimmed last night. See what happens when you do the reading? See what happens when you do the reading? Uh-huh. Yeah. Yeah, buddy. You know exactly where the reference is to go and look for the information. This is what you do. So, from August 9, 2024, when Joe Cooley and Rodney O were both parties to the case, and they were both being represented by, were they both being represented by? Yeah, they were both being represented by Fox Rothschild, the first law firm before it withdrew. So this is what they were proposing at the time. Okay, this is not the current settlement. I just want to say that very clearly. We know that they have entered into a settlement. We don't know what it is, but this lets us know what it touches on in the very least, because they said that they have reached settlement agreement for all their claims. So it's interesting that the subject line is like that. It's not everlasting base. It's like that because the Barry White Trust wants money from everlasting base and like that. So, as of over a year ago, the Barry White Trust wanted $50,000 flat payment. They wanted 30% copyright ownership of the future Metro Boomin song Like That, including the right to collect 30% of 100% of all income generated from inception and in perpetuity. Now, Rodney O doesn't have the ability to do that, but my understanding is, let me think about this, because they took him off as a writing credit. Now that I'm thinking about this. So if they want that money, it's going to have to come from a different pot. But anyway, to the extent any collections have occurred prior to the date hereof, payment of our clients 30% of those monies must be paid at the time of signing of a settlement agreement. Your client will have no future authority to license any part of the Everlasting Base song, which includes Barry White's interpolation. Wait a minute. I'm confused. Oh, they're basically saying you lose your right to license Everlasting Base in the future. Interesting. So, yeah, I don't know how much of this would be applicable given that Joe Cooley and Rodney O don't have control over like that. So we can probably strike out number 2. We can probably strike out number 3. But they are probably going after the licensing of Everlasting Base and a flat cash payment, which I'm sure has increased from $50,000. Remember, this is before everything that they've gone through that we have followed in this case. So this was at the very early stages when they had filed their claim and were very quickly thereafter trying to come up with some kind of settlement agreement. And then Necole Key entered the docket and it all went to hell. So we can imagine that there's some kind of cash payment and something having to do with the future licensing of Everlasting Base, and something having to do with the money that he was explicitly paid to use Everlasting Base in like that, because the Barry White Trust would have to go after other parties that actually have copyright and other controls over the property. So it's some combination of those things, I would imagine. Is the Barry White Trust going to sue future Metro Boomin and Kendrick Lamar? Becomes the next question. If they want all of these things, 30% copyright ownership of the future Metro Boomin song like that, including the right to collect 30% of 100% of all income generated from inception and in perpetuity, they're not going to get that from Rodney O because he doesn't have that level of control over the song. Thank you, beautiful. I appreciate you. It was pretty straightforward, and she made it unnecessarily and continues to make both of these cases unnecessarily complicated. This explains why when we were reading the emails last night, she kept referring to, settle if you want. That means that they've been trying to hammer this out for a couple weeks. And what's interesting is you'll recall they went into mediation, and mediation did not work. My recollection is that the mediator came onto the docket and said mediation is over and the parties could not come to an agreement. Nevertheless, they've still been trying to earnestly work something out. And it appears that they have worked something out. They expect it to be finalized within the next 30 days, resulting in the lawsuit being withdrawn, not to be filed against him again. But it definitely does not address additional royalties. If they want that, they're gonna have to sue. Unless they've submitted a claim for damages or hope to submit a claim for damages and immediately come to a settlement without litigation. If a part of their settlement is going to be, you can't license Everlasting Base in the future, that means that Rodney O is admitting that Barry White's composition is in Everlasting Base. So that gives them another feather in their hat if they do want to go after the principal artist for additional royalties. So we'll see. Could it rise to actual litigation, or might they just try and come to an arrangement? We'll see. We don't know. But hopefully, this first case is done. This first case is done. They've come to some kind of settlement. So, great. Fucking fantastic. But again, I go back to the emails that we read last night of her saying, you can settle if you want. You can settle if you want. You're not, doing right by your client. And I'm going to make sure that the court knows that you're not doing right by your client. It will be interesting to see if Necole Key comes back onto this first docket, wherein she has no standing, and tries to tell the judge Rodney O's lawyer isn't doing his job, and this agreement isn't in the best interest of Rodney O. Remember, she said, "I'll take care of it and you can rest." Remember that? Um, Jesus Christ. So it wouldn't surprise me if she does that. It would not surprise me in the slightest if she comes onto this first docket with some straight up biscuit head assery. And is immediately shot down because you're not a fucking party, and this court has told you on this docket to kick rocks down the block several times. But the other thing that makes this interesting is that she basically kind of threatened Rodney O in those communications, which a lot of you picked up on as I was going through the replay and looking at your comments. You were like, so is she blackmailing him or extorting him, or she's threatening to put a major filing onto one of these dockets with text messages of his associates and other artists and things like that that would be ruinous to his reputation. So if she files something, we will definitely cover it. But as of now, this first case is settled. Thank you, beautiful. I appreciate you. Because my brain really did immediately start to shut down, and I can feel the decompression coming through my body right now. Yeah, it did. It sounded like a threat. It sounded like a threat. So it'll be interesting to see where she does it. Does she do it on this docket? Does she do it on the other docket? I don't really know, but to have had some time to really think about what it is that they um were alleging in their motion to intervene, one of the things that I kind of figured out after the live is that it would appear that these things that we looked at last night, that Necole Key drafted and sent out to everybody and said were filed via EFC, there are several of them, were never actually filed with the court, but she sent them out to the parties and represented that she had filed these things. And what they said in their motion to the court on the second case to intervene was, we don't find a docket for any of these things. And there are multiple of them. Multiple of them. And then there are communications where she says, the judge has granted my motions that nobody can find. And then she represented that in communications with the parties, with Sony, et cetera, et cetera. So it was too much for me to wrap my brain around during the live because it's nonsensical, right? It's nonsensical. It's like, oh, she created these things, didn't actually ever file them, served people with them, told them they were filed, told them the judge gave me this and the judge granted me this, and those things never happened. Never. Never. So I'm sure it was just a technical glitch, you know? But yeah, 20 minutes and 14 seconds. Baby, I'm not going to be staying too long either. So yeah, I encourage anybody who did not catch last night's live. I mean, we just had a live, but on this, anybody who did not catch last night's live, watch that. You need to watch that. You need to get all caught up into, because all of that still exists and is relevant, even if this first case is getting settled. Everything we went over last night is still timely, relevant, still happening. So you'll want to, you'll want to get those updates. And yeah, I guess I would imagine that when all of that stuff got filed, she like probably laser focused in on that. And now that this has gotten filed, she's probably trying to figure out what does she want to fuck up first. You know? What's her priority level for what do I try and fuck with first? This settlement or them trying to intervene in my lawsuit to get it dismissed, which is still wild to me. They made it pretty clear in their communications with her that if they have to sue her, and this is Rodney O, that they will sue her. It's really unfortunate because he's probably lost at least a third, if not half, of his initial publishing deal with Sony of that upfront 495,000. He got a chunk to hire the first law firm, right? She got paid a chunk for her 10%. He may have gotten another chunk to get additional lawyers, or they have a contingency agreement that that lawyer is going to get money. Then he's got to pay out a cash settlement on this first lawsuit. One of the things that they may, now that I'm thinking about it, one of the things that they may have said to him is that because I don't know if he would be willing to do this, but I guess it wouldn't make a difference if he did, because if part of the settlement is you cannot license Everlasting Base in the future, that's what they originally wanted in 2024. I believe that was August 2024. That could have transitioned over to give us the copyright and we take over as the recipient of any royalties on that. I don't know. We'll see. I mean, I don't think we're ever going to actually see right what the actual agreement is, but if there were some kind of material change like that, that's publicly available information. Or they're going to have to sue for it. So it's going to be interesting to see what happens. But nevertheless, really unfortunate that because of her and all of her actions, he's got these attorney's fees on this. Then he's got to pay his attorney to deal with the second lawsuit. He's not really going to have much left from that initial pot of money that he's been fighting and begging, excuse me, to have released to him. That shit is all going to go to lawyers and damages, and he'll have a little bit left. But I would imagine if they wanted 50,000 straight cash a year ago before all of this started, they pushed that number to at least 75. At least, if not higher. The sample did clear. There was a challenge after the fact. So the sample did clear and they used it. And after the fact, it was not until after the fact that the Barry White Trust said, that's our composition in like that. And it was, well, that's actually Everlasting Base. Okay, that's our composition in Everlasting Base, which is in like that. And there was a little bit of time ago, somebody said, well, they can't sue Future and Metro Boomin because they didn't know. It doesn't work that way. It doesn't work that way. If they can prove that Barry White's composition is in the song, then it's infringed work. Period. It doesn't matter if the sample cleared. It doesn't matter. No, it's not. It's not greed. Well, it depends on who you're talking about. Let me say that. It depends on correct. The sample in Like That is Everlasting Bass. And that was made by Joe Cooley and Rodney O. Within that is, according to the Barry White Trust, one of Barry White's songs, I'm Gonna Love You Just a Little Bit More, Babe. So, yes and no, right? It is. It is. And we never got to, you know, we never got to the point of expert testimony. And we don't know what expert evaluation they've had done behind the scenes that they would then be using to negotiate a settlement. We don't know. We're not privy to that kind of information. Not everything, not all information that is surfaced, not every move that happens in litigation comes onto the docket. It usually only comes onto the docket when there's a problem, right? So, but that's the sequence of events, is that Everlasting Bass was licensed for the use of Like That. And after Like That came out and this became a whole big thing, the Barry White Trust was like, that appears to be our song. And then it kicked off from there. And the first people that they went after was Joe Cooley and Rodney O. Well, that's what I'm saying. Yes, that's what I'm saying. There's 3 components here, or 3 different works, okay? There's the Barry White song, which is inside of Everlasting Bass, which is inside of Like That. So, the Barry White song is inside Everlasting Bass, which is inside Like That. Did I explain it better that time? The producers of Like That did not know. Rodney O's initial representation was, "Nuh-uh. Nuh-uh. That's not a Barry White song. It could be similar to a bunch of different songs. Nuh-uh." But we never got to the point, we were not getting to trial, right? So we don't know what experts say. We just know that the Barry White Trust has said, "That's our shit." And instead of addressing that, Necole Key made it a whole issue of technical. Before 1979, they got to produce this, and after 1983, per rule, you know how she do, right? So They just red herringed all over the place. All over the place. But the judge said all that shit is pointless and not going to get you anywhere. And the Barry White Trust just continued to represent that is ours. That is ours, written by Barry White. Put it in a filing, told the whole story of Barry White and how he came to compose and write music, because that became an issue at one point in time. Where's the composition? They never heard the song. It's that simple. Hold on. This might be a repeat docket alert. They hadn't heard the song. Is this a repeat? Okay. The Barry White Trust just filed a motion to dismiss the second action. Oh, come on, chair. Are you stuck on something? What the fuck? Just move 2 inches. God. It won't. Okay. Give me a second. Let me pay for all the documents. Oops. They dumped a bunch of stuff on the docket, but nothing that's 300 pages. Oh God, I thought that said 830 pages. I was about to say, I'm out. All right, chat. It's been real. It's 6 pages. Sorry. Oh God, I was no fucking way. Well, I guess this live is going to be a little bit longer than I thought. I thought I was just going to tell you settlement. Here's what it could be. Bye. This is a declaration. Wow, they've been working their asses off. And this is, oh God, this is what yeah, these parties are working very closely together because Hold on. I got 2 more things I gotta download in there. It's a government website, y'all. It takes a minute. Is this a rhetorical question? What do you want from me? What do you want from me? They didn't hear it. It wasn't caught. I'm sure that they probably have all of the things in place, the DCMA and all of that stuff to catch it. It wasn't caught. It just didn't happen. I don't know what you want me to say. But you can't assert failure of due diligence. They represent that they became aware of it at the point that that came out, and they were not aware of it before. It's that simple. It's literally that simple. But you can't say, "Well, they didn't do their due diligence." They didn't know. They didn't know. I can't give you anything, better than that, and it's okay if it's not satisfactory to you, but I don't know what you want me to say. Um Oh, fuck. Let me focus. Just paid for something I didn't need to pay for, which is my fault, not yours. Okay, one more, I believe. Okay, now let me open all of these things, get them on screen. It's gonna take a second. It's all good, it's all good. Well, thank you, beautiful. You too. I mean, that's one way to put it. That's one way to put it. I'm trying to get these damn documents to open, and they have not. Sure, let's click on them 16 times. Love how we move at a glacial pace. Okay, let me get these in order. I really don't like Adobe. I do not like them, and I do not like their monopoly. Okay? No, I do not. That little waddle butt ain't gonna do nothing. You gonna be just fine, but thank you for the support, beautiful. I appreciate you. You're vastly oversimplifying the process. Okay? Vastly oversimplifying the process. They're talking about composition, not sound. You all are looking for a one-to-one match on sound. They're talking about musical notes, and composition. Okay? So it's a little bit more complicated than that. Jesus be a oh yes. Horrible. Yeah, as long as it's within their, 70 years. Yes, true. Me too. Me too. Me too, me too, me too. Me too. I've got some lifelong version. I can't remember which one um it is, but it's not Microsoft Office because fuck them. Okay, let's get into it. Thank you for your patience. I really love how instead of just going with case name, they're like, the plaintiff here is Necole Key. Okay. So this is the Barry White Trust because they are being sued by Necole Key. Okay. So this is the second action. This is Necole Key versus the world, including Barry White Trust, Sony, Epic, Universal, lawyers, Future, Kendrick, Metro Boomin, John Doe's 1 through 10. Okay, so this is their official motion to dismiss. Defendants, the Barry White Family Trust, upon the accompanying memorandum of law, declare the declaration of Rodney Oliver and the declaration of the attorney in support of the family trust. Motion to dismiss today. Again, same judge. Yeah, they're not fucking around. It's 34 pages. It's not that bad. We'll be able to skim quite a bit because we know this one like the back of our hands. So this isn't something that we're starting from the beginning. Good God. Their table of authorities is ridiculous. This action was brought by the plaintiff Necole Key after the court denied her motion to intervene in the Barry White Family Trust versus Oliver, the first action. Thereafter, Key and Rodney Oliver entered into an after-the-fact co-ownership agreement without any consideration, which Key then used as the basis to commence this action. Key's agency and the co-ownership agreement with Oliver were both terminated by Oliver September 2. See Exhibit 1. Oliver voluntarily dismissed the second action against all Barry White Family Trust defendants without prejudice, which was so ordered by the court. The frivolous nature of this case is striking. The following are the undisputed facts. Oliver is the only party to any of the agreements that are at issue in this action. The parties entered into a master-only co-ownership agreement without consideration. Oliver has told Key that the co-ownership agreement was terminated. Key, at all times herein, was acting as an agent for a disclosed principal, Oliver. The only two acts alleged regarding the Barry White Family Trust defendants are the notice of infringement and litigation hold letter and the filing of the first action. Okay, blah, blah, blah. After the court denied Key's motion to intervene in the first action, Rodney O, in relying on his, at the time, agent, Necole Key, entered into the co-ownership agreement in connection with Everlasting Base. Key orchestrated this agreement to create an illusory basis for Key to assert ownership and for the express purpose of pursuing the claim in circumvention of the court's order that she does not have standing. Key's continuation of this second action is the antithesis of Key's fiduciary obligations to her principal, which would be Rodney Oliver. Key's own words reveal her deliberate intent to evade the court's order through the fiction of an actual co-ownership agreement. Key does not retain ownership of the master sound recording from the co-ownership agreement after termination. At times, Necole Key seems to conflate the agreements for publishing and masters, and this action relates solely to a purported infringement of the masters, not the underlying musical composition. On April 28, Key sent the following text message to Rodney Oliver regarding the agreement for the court's perception. That's a quote. For the court's perception. Quote, I made it look as common as others, but you are the one that can terminate at any time to avoid me having to write on blah, blah, blah. Everything will remain as is, just in the court's perception, it changes. Okay, and then they get into case law of why she does not have ownership. Key purports to allege the following causes of action against the trust: fraudulent misrepresentation, economic duress and coercion, interference with contract and economic advantage, civil extortion. It is submitted that not only are the causes of action improperly pled, but they are also not supported by facts and are unsupportable as a matter of law. Key's claims should be dismissed with prejudice. The Barry White Family Trust defendants' arguments may overlap with other defendants' position, and to the extent other defendants raise the same argument, the Barry White Family Trust defendants will join their motions to dismiss as well. Key is using this action as a self-serving cause célèbre, and her status, misconduct, and termination as an agent supports the objective unreasonableness standard herein. Key's bad faith posturing and legal position is particularly egregious since, as an agent, she is acting in a manner clearly at odds with her fiduciary duty to Rodney O. Rodney O, in no uncertain terms, repeatedly advised Key to drop the lawsuit. Quote, I spent over $1,500 on service and now I don't want to go forward because I'm tired of fighting them and you. You tell me you don't trust me, but I signed a paper to get you in on the case and now you're using it against me when that wasn't supposed to happen. All this got way too personal when it should not be. I know you worked hard, but didn't know it would have us at odds. So no, I'm not going forward with the next case. I want this over with so I can have a life. Notwithstanding that defendants do not need to make a showing of bad faith, Key's actions are clearly done with or in bad faith and some misguided attempt to gain publicity for herself. This is all particularly ironic in view of Key's many posts positioning herself as the savior and protector of artists' rights, while at the same time placing herself at odds with Rodney O, a clear breach of fiduciary duty. However viewed under New York law or California law, Key's conduct is squarely adverse to the express directions of Rodney O. And then they get into California law. They're covering the spread. We don't care if you consider it through the lens of New York, through the lens of California, where they are. No means no. Okay, so failure to state a claim because she doesn't know how to plead shit. Failure to state a cause of action because she's not a lawyer and she doesn't know what the fuck she's doing. Nowhere in her rambling 15-page complaint does Key state any fact that relates to a use of the Everlasting Base master recording by the Barry White Family Trust defendants. The remaining causes of action lump multiple parties into a hodgepodge of nonsensical claims, and in the case of her seventh cause of action for civil extortion, it is a cause of action not recognized under New York law. In point of fact, there are two operative facts relating to the Barry White Family Trust Defendants Counsel, May 7, 2024 cease and desist letter, and the complaint filed in the first action. Key was Oliver's disclosed agent to third parties, charged with the fiduciary duty to act on his behalf and only consistent with his wishes. Since Rodney O terminated both Key's agency and her temporary basis for asserting ownership over his intellectual property, Key has no standing to bring this case or assert the claims that are rightfully Oliver's, as Oliver, not Key, is the party to the contracts in question. If a person is deemed to be necessary as a required party, the court must order that the party be joined as a party. And they already determined she's not a party. So this is just a bunch of case law. The claims against the Barry White Family Trust defendants are compulsory counterclaims in the first action. So they're already being dealt with in a different lawsuit. Clearly, the claims asserted in this action are rightfully Rodney O's claims, not Key's to assert. As set forth in Oliver's motion to intervene, the claims against the Barry White estate in this action mirrored those in the counterclaims Key filed for Oliver in the first action. The remaining claims in this action are supplemental and not supported by a federal claim. To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim of relief that is plausible on its face. Oh, we know Kaplan. We talked about that a lot. The court may also consider documents incorporated in the complaint by reference and matters of which, judicial notice may be taken. You fucked, girly. How you doing? I'm sure you're watching. You're fucked. Judicial notice is appropriate when a matter is not subject to reasonable dispute because it is generally known within the trial court's territorial jurisdiction or can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. Key has no standing. The causes of action in Key's complaint gives rise to a contract claim against the other defendants and not a copyright infringement claim. The court has no subject matter jurisdiction since Key has no standing. Key no longer is a copyright owner nor signatory to the agreements which are the subject of this second action. Her agency was terminated. Standing is a constitutional requirement under Article 3, Section 2, Clause 1, which limits federal courts to adjudicating actual cases or controversies. For there to be a case or controversy under Article 3, the plaintiff must have a personal stake in the case, in other words, standing. They pulled the Constitution on you. I know I said it a couple minutes ago, but I'm going to say it again. You're fucked. Okay, and then they go through a bunch of case law. They shred her argument about standing. And they line it all up with a lot of case law. Dismissal at this stage is appropriate. Federal courts do not exist so that plaintiffs can roll the dice on unreasonable allegations or so that they can seek fame and fortune from deep-pocketed defendants. And case law. Point 4, the complaint fails to state causes of action on state law. So this is just a bunch of more legalese of how she's not reaching any bar. She's not reaching the required bar of state law. She's not reaching the required bar of federal law, and she has no standing. All of her claims fail as a matter of law, which is what the judge has purview over. She's failed to allege essential elements. A fraud claim under New York law consists of 5 elements: a material misrepresentation or omission, knowledge that of the fact's falsity, and intent to induce reliance upon that false information, justifiable reliance by the plaintiff, and damages. She ain't got none of that because she didn't plead it, and she can't plead it now. They're going back to she's not reaching the federal bar. She's making fraudulent misrepresentation claims. Economic duress and coercion are not causes of action. This is why you don't rely on ChatGPT to write your legal pleadings, or a cease and desist, in case anyone was wondering. There is no interference with a contract because she's not a party to the contract. The agreement is between... Oh, yeah. Well, bottom line, she's not a party. They just go through all of the technical, what entities are responsible for everlasting base. As an agent for a disclosed principal, without the principal's participation, she may not maintain the lawsuit. They're just continuing to beat down all of her stuff. We're on 26 of 34. Key has no business or contractual relationship with Epic or Sony, as those agreements were solely in the name of and for the benefit of her former client, Rodney O. She has not been harmed in any way. Civil extortion is not a recognized cause of action under New York law, so that should get tossed. The Barry White Family Trust defendants request injunction relief against Necole Key. The only deterrent sufficient to prevent Key from filing yet another baseless complaint against defendants are to award the defendants attorney's fees expended in defense of this frivolous second action, and an order precluding Key from further filings against defendants without leave of the court. So you can't file shit in the future unless you get permission from a judge to do so first. They want attorney's fees, and they want her barred from being able to engage in future litigation. When considering whether to impose an anti-filing injunction, a court should consider the litigant's history of litigation, and in particular, whether it entailed vexatious, harassing, or duplicative lawsuits, the litigant's motive in pursuing the litigation, whether the litigant is represented by counsel, whether the litigant has caused needless expense to other parties, which they've already showed in the first cause. Yeah, in the first cause of action when they went for sanctions, they've already shown where they were forced to spend more money. Remember the 45 filings at the time? That was all done by Necole Key. Okay, so whether the litigant has caused needless expense to other parties or has posed an unnecessary burden on the court and their personnel, and whether other sanctions would be adequate to protect the courts and other parties. Due to Key's history of nonstop filings in the first action, the court has ordered that the defendants need not respond to any submissions by Oliver and Key unless ordered to do so. An anti-filing injunction is proper here. Key's actions are harassing. Key has no good faith basis in continuing to pursue this litigation. Key's conduct has caused defendants to spend unnecessary high costs in addition to placing a burden on the court, and Key's history shows that no other sanctions would be adequate to stop such conduct. Now they're going through and arguing how New York law should have prevented her from how New York law prevents her from even arguing many of these claims, even if she had standing. And also the privilege of attorneys to not be sued for doing their jobs as attorneys. It's not malpractice. So you can't sue an attorney for working in good faith and filing things on a docket. All of the conduct alleged by Key against the Barry White Family Trust defendants after the filing of the first action took place in the course of legal proceedings, and every act, statement, and communication that Key attributes to the Barry White Family Trust since that date has been pertinent to the pending infringement litigation. So she's saying they're harassing her. She's saying this lawyer is saying everything was necessary and in line with litigation, and the judge has previously agreed with them in the first action that she reviewed everything that Necole Key alleged that they were doing and said, and the judge said, this is litigation. These are lawyers that are litigating. Yes, I looked at every single thing you submitted to the court to say that these people are railroading, that they're untoward, that they're scheming, that they're plotting, that they're doing all of these things. They're litigating. This is litigation. You wouldn't know that because you're not a fucking lawyer. Miss Key claims defendants should be subject to liability for disparaging plaintiffs. Her pleading includes a prayer for injunctive relief from disparagement. Miss Key reserves her right to amend because of reputational damage and emotional distress. So they've gone through all of their shit. Then, okay, so that is their motion to dismiss the second lawsuit. Then they're not done. They filed a bunch of shit. And this is how you can tell that these parties are working in conjunction with each other. Memorandum of law in support of Rodney Oliver's motion to intervene in the lawsuit where we are being sued. So this is very short. It's only 4 pages. I'm just going to look for anything that is really striking. But ultimately, the Barry White Family Trust defendants do not oppose the intervention of Rodney Oliver, who is a necessary and indispensable party. They besties now. Joinder would prevent needless duplication and promote judicial efficiency. And they kept this short. It's 4 pages. So again, they say, we do not oppose the intervention of Rodney Oliver. Allowing proposed intervener to proceed in this action promotes efficiency and conserves party and judicial resources. First, proposed intervener is the real party in interest. Second, it cannot be disputed that Rodney Oliver is a relevant party in this action and that his alleged ownership of the Everlasting Base Master and his principal agent retaliation with Necole Key and the series of events giving rise to this action are central to this action. It's funny that they say in here, keep in mind what we started this live for. And keep in mind what I said about, I wonder where the ownership of Everlasting Base is going to wind up. Now let's look at this document in this sentence again, where they say, Rodney Oliver is a relevant party in this action, and that his alleged ownership of the Everlasting Base master. Judicial efficiency is a thing, and it is of utmost priority for the courts. Yes. This is what working in good faith means. You can be on opposite ends of an issue and not be maliciously adversarial. You can it's called being a fucking professional. That's it. Ooh, I love how you focus on the details here. Let's make sure we cover all bases. Tight jacket, arms in the back, muzzle. Mhm. Mhm. This is too much. It is also respectfully submitted that Necole Key's claims are without merit and should be dismissed as set forth in their motion to dismiss, which we just read. Conclusions. Like I said, they kept it short. We do not oppose. Here's why we don't oppose. So yeah, they're working in concert with each other. Okay, settlement, we already looked at that. This is a declaration of Rodney O. I was a plaintiff in the above caption matter, and I am a defendant in the first action. In September, I instructed my attorney to file a dismissal without prejudice in the second action. Prior to that, terminated Necole Key's rights under the master recording agreement from April, a copy of which is attached to the complaint as Exhibit B. Ms. Key has admitted that my termination was something I always had the right to do. Ms. Key acted as my disclosed agent for the agreements referenced in the second action, the Eric Weissman agreement, which is Exhibit B to the complaint in the second action, and the Sony Songs agreement, a redacted copy of which is attached here too as Exhibit 2. On September 2, I terminated Necole Key's representation in connection with all my business matters. Ms. Key has no right on her own to bring this second action. I have terminated her rights and her authority. I reserve all my rights in connection with Ms. Key's bad actions here in maintaining a lawsuit she has no right to maintain on behalf of my solely owned copyrights. So what he's saying when he says I reserve all my rights in connection with Ms. Key's bad actions, he's saying I reserve the right to sue her. Okay, we're going to skim. Oh, I don't know when this is from because, sorry, I'm going to have to zoom way in to get a date on this. I don't think I can zoom in any further. September 29, 2025. A text message from Necole Key. You had the ability to take the masters back the whole time. I never have done your wrong. Now please go away and leave me alone. I won't forgive or forget how you treated me. Just go away. Let me zoom out here so that I can get my bearings. Because, dear God, that's brat. That's brat. Right. 5 or 6 weeks ago, and before she went into that whole back and forth with his lawyer. That was in October. So this is prior to that. And that is a concrete right there. You have the ability to take the masters back. Okay. Yeah. More text messages. I don't know who these are to and from, but the first one says, now you want 20% of what he ends up with. And she says, yeah, so I am able to speak and tell the court everything I know and have them pay for what they did. That was the agreement. These are like screenshots of a device, so it's hard to see. You know, if you would have said that beforehand, he would have never signed it over to you. Said what? I've been saying this, I haven't changed that. I think if that happened, you'll get yours. But if it don't, it's in the air. Oh, this is interesting. Remember when she said, what if I put your homie's text messages on the docket? Homie's text messages put on the docket by who? Rodney Oliver. You threatening him, you'll take him to court, Necole. You're doing something to him. How am I threatening him? He is twisted, delusional. You said you're not signing his masters back. Then pay me fairly, unless he pays you what you want. I never said am not. That's a lie. That's what you do when someone works, you pay them. Am not wrong. But he only signed half of that to you so they would let you in the case. You were supposed to sign it back over to him. I don't want the money. I want it to be known what they done. It was done to me, not you, over your music. I am not scared. I have every right to move forward. You can do what you want. We agree it was our terms. You went rogue and decided to quit. I don't have to. This is a different conversation than the one we just looked at. I believe this is back to her and Rodney O. And Rodney O says, you're right. It's all about Necole. Her, leave me alone. Oh, believe me, I'm trying. Her, for years I protected you, and now I'm still protecting you, and you want to hurt yourself, so do what you want, but I refuse to not follow through. Of course you do, because it's all about you and how you've been wronged. Okay, carry on. If that's what you think, fine. I'm not rolling over. You will have your music 100%. If I keep fighting, you want to give it away, do what you want, but I will keep fighting. I am the one that has been attacked. They are trying to make me the scapegoat. I have to defend myself. Why are they so worried about me if they were in the right? You subpoena me, so now I can't walk away. That's what you do. Fight with everybody. And when they punch back, here comes the tears and the blame. I'm no different. Fuck all the good I did. It means nothing. You hijacked my business and holding me hostage. It's my case to do what I want. I don't want to fight. I want to move on and live my life. You have something to prove. It's sad to be honest, but do what you want. Her. The judge held off sanctions because she sees what's happening. Bitch, she held off sanctions because she sees that you're the fucking problem. You said it was ours. Was that a lie? 50K in sanctions is not holding off, and it's my music, not yours. You don't have to like how I feel, but I get the last say, not you. You have some nerve. but okay. Her. You don't have to stay. The judge allowed you to withdraw, so do what you want. And stop dragging me into the case you are in. That was Ken's failure, not mine. He should have closed discovery and went to summary judgment. Oh God, this bitch doesn't know how the fucking process works. I'm so sick of her. Sorry. Him. All that, it's not about the money talk. Yes, it is. Everybody thinks they know what the judge is going to do is some bullshit. Only she knows. High five, Rodney O. High five. Head on straight. This boy got his head on fucking straight. I'm so relieved because I thought he was crazy. I thought he was totally boop boop. That's a good one. That's a good one. That's a good
High
one.
five. I'm bulletproof.
If I don't want to move forward, that should be my decision. You don't have to like it, but it's still my decision, my life. So, okay, no more words. Her. Yes, in the case you are in, first lawsuit, do what you want. But the one we filed together, second lawsuit, you don't decide what I do. Only what you do. You withdrew, so now it's all on me. Anything goes wrong, it's on me. I bet it's all going wrong. It's all going wrong. You're insufferably horrible. Him. Thanks for showing me how you get down when you don't get your way. What a way to live your life. It's fucking sad. If people don't agree with you, doesn't make them horrible people. Her. That's for going back on your word and turning your back on me. To protect you don't want to protect your music. Don't. I will. Him. You still don't understand. I can't move forward and get to no money with you standing in the way. And that's what you're doing. Like it's cool. It's not. But you don't give a fuck. Only about trying to prove you've been wronged. Everybody has been wronged in this business. So what? And move on. You can't. So this is the agreement, or at least part of the agreement between Rodney O and Sony Music Publishing. Obviously, we're not going to see the majority of it, but that's what this document is. I'd just like to remind you that we are looking at Rodney O's communications, Rodney O's contracts as entered onto the docket by the Barry White Trust. Not his lawyers. That was last night. That was different shit. This is new shit. We didn't look at this last night. Okay. All right. Let's get the fast scroll going. Good God Almighty. I can't remember what all the attachments were, so there could be something after that, after this, which is why I'm going through the whole thing. Signature page is it. Okay, moving on. So this is just her. This is the attorney. This is the Barry White Family Trust attorney's declaration to the court with everything that she chooses to submit. So this is a copy of the, let me just say, I'm getting a little flashback. I'm sorry. I used to have this printer, and it's one of the worst fucking printers on the goddamn planet. Okay, I'm getting a little bit of PTSD, but this, what she is showing that they have, is that this is the BS agreement between Rodney O and Necole Key. Oh, yep, there it is. And there's her text message. I made it look as common as others, but you are the one that can terminate at any time to avoid me having to write. On everything will remain as is, just in the court perception. It changes. I have no idea what the, oh. This is Rodney. Can you give me enough respect I did and let me know if you are part of the second case? I had to come out of pocket to serve parties because you ignored my text. All I ask for once is to tell me and not behind my back. And that's when he sends the, I spent over $1,500. Let me see. Is there anything else in here that I missed? We looked at that yesterday. We just looked at that watermark settlement. We just looked at, yep, we just looked at that. We looked at that. We looked at that. We looked at that. That was record timing. That was record timing to go through those things. Okay, so let me check. Make sure I don't have any additional docket updates. This is really trying to think what kind of titties to invoke. Tough titties. Definitely. Tough titties. Baby, I'm seeing it as you're seeing it. I haven't fiddled with anything, okay? I have not fiddled with anything. But I will tell you that there have been plenty of times where in a court filing, you see somebody's Dropbox or the Google Drive where they have put the things, you find it in a filing like that in communications. And I have definitely copy, paste, and gotten access to file folders that way. Just in general, in life. They settled. So they settled. The I am so confused. I am so confused about the lives that I've had. Okay, so at the beginning of this live, right, chat? Check me, because we've had 2 back to back. We've had 2 back to back. I came back to tell you all, right? right? I told you, as soon as it was over, the camera was down, light was off, glasses, I don't even know where they are. I was starting to shut down the brain, you know? And then I saw the thing and I was like, "Oh shit." So I'm struggling right now. I came back to this live to tell you all that the Barry White Trust and Rodney O have entered into a settlement agreement on the first main lawsuit. Yes, that is where we started. Then, as we were talking about what that settlement could entail, we got a massive docket drop on the second docket, which is the Barry White Trust coming into the second docket with number one, their own motion to dismiss the second lawsuit. Number two, yes, please, we'd love to have Rodney O intervene in this case. He is central to it, and the one withstanding. She doesn't have it. Then the Barry White Trust, present a declaration from Rodney O. In addition to the declaration that he submitted last night through his attorney. So they are like this right now. Litigation wise, strategy wise, the Barry White Family Trust and Rodney Oliver are like this. And we know that the Barry White Family Trust has been tired of Necole Key's bullshit for a very, very long time, and they want sanctions. They want sanctions on her in the second lawsuit, and they want her declared a vexatious litigant, and they want an injunction that prevents her from filing any court action in the future without prior approval from the court. Toughest of titties. Toughest. As I said last night, when we first started this, formatting almost completely took me out. I was like, is this what we gonna have to deal with, y'all? I'm not gonna make it through. I'm not gonna make it. Now look at us. Look at us several months later, several seasons later, as a matter of fact. We've gone through all the nonsense. And from the moment it wasn't even from the moment that Rodney O hired a lawyer, because Daystar Peterson. It was the moment that I went and researched his lawyer. This dude's resume is no fucking joke. And the first indicator that we had that the lawyers were working really well together was when they both came forward to the court in the first action and said Necole Key is fraudulently filing things on this docket. And now they've come back, both parties have come back even more forceful in the second case. This document was forged. This signature was faked. These things that she is serving us have never actually been filed with the court. I am concerned. If she actually does have filings, documents that she served to the parties and represented that she filed them in the court, and then represented that she received favorable rulings, and she never actually filed them with the court, I do think that she needs to be evaluated. Because do you believe that? Do you believe you filed it with the court? And do you believe that the judge actually gave you favorable rulings? Then you're delusional, beloved. You're delusional. So either you're delusional or you're a full fucking fraud. And you maliciously perpetrated a fraud on multiple people, multiple entities, and the court. Either way, you deserve everything that is coming to you. Everything. I'm the victim. You're not. Ship it to her. That's perfect. Ship it to her. She deserves it. Yeah. And her interpretations of things, that's what is crazy to me. You know, she told Sony in writing, Rodney O was cleared of any wrongdoing. This case was dismissed against him and Joe Cooley back in whenever they dismissed it against Joe Cooley. And then she attached irrefutable proof that it was not dismissed against Rodney O. And Sony was like, we're going to go ahead and just CC Rodney O's lawyers because, Heffa, what are you talking about? You just said one thing. Attach something that proves the exact opposite, which is public record. Everybody knows that he was not cleared of any wrongdoing. Everybody knows his lawsuit was only withdrawn against one person. You attached it in your misrepresentation. And since you're not a party, we're going to go tell Rodney O's lawyer. That's just wild behavior. And it's people like that. It's people like that. Let's remember, not only are there actually, court rules, right? But there's rules to engagement in war and battle and disagreement. And one of the tenets of the unwritten rules of engagement is integrity, right? For example, if you are served something or you receive an email, if you then go on live and misrepresent what the email is, you have gone outside of the acceptable rules of engagement because now you're a fucking liar. You're twisting and manipulating the facts to serve your narrative because if you did represent the facts, you'd be fucked. It'd be real clear that you're the one in the wrong. But you need to manipulate the narrative so that you can get other people to be sympathetic towards you or to gang up on somebody else. Timely example. So people who do that kind of stuff have no fucking integrity. They're slimy, manipulative, and they do shit like this. Make shit up, insist it's true, and try and force other people by any means necessary, hook or crook, bullying or harassment, to adopt their narrative because that's what works for them. Well, you're fucked too. So. I'm so glad you're still here. I wasn't sure if you had tapped out. I know you said your phone was running low. I wasn't sure if you had tapped out before we got the big docket dump. It's a lot. It's a lot of AI psychosis. You know? You know? So so yeah, I mean, this is huge. This is massive. This is massive. Last night was massive. This is also pretty fucking massive. They have linked up, combined forces, sharing information, Sure, I'll give you a declaration for your filing. Sure, I'll give you screenshots of my conversations with her, other people's conversations with her. Sure, I'll do that. Rodney O has decided we're fighting. That was clear yesterday. And once the sequence of events were laid out of like, first you, Rodney O, have to do these things, and then these things are going to happen. And to bolster those things, you will need to do these things. Like, he had to be 100% committed. His lawyer had to know that he was 100% committed to seeing this course of action through. And he, by reading their text messages, he is fucking fed up with her. He's at his wit's end. And it was, it was almost like a near death experience for him, right? We know that even though he wasn't sanctioned by the court, he came real close to a default judgment of sanctions, of losing the first case through a default judgment of the judge saying, you are not engaged in this litigation in good faith. You lose the case. And he mentioned the number $50,000. So the judge was prepared to also start putting some numbers towards it and letting him know, you're not just going to lose, you're going to be paying some money. When she was like, you didn't get any sanctions, there's nothing to worry about. He said 50,000 was not nothing. That's hanging over his head. That's another cut out of his money. And then at that point in time, you don't get any settlement agreement between the parties. The judge determines that you lost because you can't engage in litigation in good faith, and then determines what damages are outside of your control. So I said from the gate, arbitration or mediation for Rodney O is going to be the best thing. And if he does not have a lawyer, there's no possible way that these people are going to engage in arbitration or mediation in good faith. There's no fucking way. And he got a lawyer within weeks of mandatory mediation. They did not come to an agreement within that time frame within the mediator, but they clearly made a shit ton of headway. And then again, she came back with a made up, totally fraudulent 20% agreement and gave it to Sony and said, give me 20% of Rodney O's money. And I think that was the impetus for what we got last night. But we know that these things were weeks in the making. It is November. They got their declaration from Rodney O October 8th. The declaration we just read that the Barry White Trust put on the second docket, they got that from him on October 8th. Sequencing. Things take time. When people want to, well, what about this? And I thought you said, and I need it. You just have to wait for the normal course of the process to occur. And if there's more relevant information to share, it will be shared. Sequencing. Things take time. I don't know. I don't know. I don't even think that it's that she likes to instigate. She is self-important. This is all about her, just like he said in her text messages. Oh, right. It's all about Necole. This is all about her. We got that from her messages last night. I'm about to prepare it's going to be the best filing yet, and it's going to get the attention of the media. One pro se defendant taking on 2 lawsuits and protecting you. And all you got to do is say the word, baby. I'll take care of it. You can rest. She may have not said baby, but you get the point. This is all about her and her proving that she is not a pathetic person. Her proving that she knows how to master and wield her authentic power, which she has confused with external power, which is the law. This is all an ego exercise for her. If she's not the winner, she's the victim. And she's never going to lose outright. No, they have to be dirty. They have to be dirty for her to lose, because she has already decided she's right. She doesn't even give a fuck what the judge says. She has already decided she's not a fucking lawyer. And she has already decided that she's right, that she has the strongest case, and that she's gonna win. You can't decide that about your case going in. Even when you have people dead to rights, that doesn't mean you're gonna win. And anybody who works in or around the law will tell you that. But she has already decided she is the judge and the jury. She is it in her fucked up, twisted little mind. And if she doesn't win, it's because people maliciously plotted against her, including Rodney O, to force her to lose. But she will never, ever, ever be wrong. Ever. Ever. She will just be a victim. At the beginning of what? This? Or back in the day? Leeching and siphoning. Yes. Yeah, and she's not blocked now. She's just smart enough to not say shit. Because I won't go tit for tat in the chat. I'll drop a link so fast. Come on to the live. Come on to the live. Since you like having your ass publicly whooped. Because I have just a few straightforward. I want to look you in your eye and ask you these questions. But she won't do that. Because this space is not conducive to the narrative she has created in her head. She is the valiant one. Or she is the victim. But she is not wrong. And that's a person you can't negotiate with. That's a person who you have to say, Your Honor, we need a jacket with the arms in the back and a muzzle. And this link up right here, my personal opinion is that the judge is going to say that Rodney O can intervene. Remember, this lawsuit is in his name. It's Oliver versus everybody. So it's in his best interest to get rid of it. And he doesn't want it. He's made that very clear. I do not want this lawsuit. If I was going to file a lawsuit, it would not have been at the time when Necole filed it. So we'll see. We'll see what happens. We'll see if she comes onto the docket. We'll see if other defendants come onto the docket. Just like, hey, we know that our official response isn't due until the 6th. And we're going to meet that, Your Honor. But we just wanted to pop in and say, we are also not opposed to Rodney O intervening in this action. It wouldn't surprise me if any of the other parties came onto the docket just to submit that to the court. Just to submit that. And then see what happens. They still got a little under a month before they officially need to respond to this lawsuit. But they could very easily pop onto the docket to say, yeah, we think it's a good idea too. And Rodney O is the one who's trying to put this on his back. He's trying to put this on his back to make it go away so that other people who he would hope to have a relationship with in the future don't accrue a bunch of fucking legal fees because his former agent is suing everybody in his name. That's not good for networking. Now, is it? This is fair. This is fair. Didn't they put Hannibal on a dolly? Basically. Didn't they have him on a, a stretcher connected to a dolly? We could do the same thing for her. Ankle restraints? Reasonable. Reasonable. Oh, we got the mask. The muzzle mask needs to happen. Somebody already pointed out. You can audible to Chat GPT. Put her in the same kind of thing that Magneto was in, so no electronic signals can get in to her facility. That too. Yes. Delulu, baby, Delulu. It defies rationale. It really does. So I'm glad this is happening right now because I was also kind of like, fuck, December? We gotta wait till December for this shit to go down. Jesus Christ. The level of summary that I'm gonna have to do to remind everybody in December. Okay, remember first this happened, then this happened, then that happened. Nope. We got a good, we got a good midway point. A good brush up on, okay, so remember all the things that happened, child. Guess what's going on now? What? You all wanted to, first of all, jacket with the arms in the back. Second of all, muzzle. Third of all, I don't trust her legs being free. I felt like the next natural iteration is the safety and security of the facility. Shit. Oh gosh, let me refresh this one more time. Okay, good. There's nothing left. That the Barry White trust attorneys are on the East Coast, so this is probably the last thing that they did before shutting it down for the day. Was making sure that all of this was done and filed. I mean, okay. I'm also not opposed to this. I'm also not opposed to this. We could give her the face-off prison boots. Just to the ground. Can't go anywhere. That could also be nice. It really could. This is what it comes down to. Safety first. Safety first. Ours and hers. And hers. And hers. Because, baby, you're gonna have to pick a different genre and a different culture of music to go work on now because your business in this in this corner of the industry is over. Is over. Because, excuse me, Rodney O is going to tell everybody, "Do not work with this woman. She's crazy." It's a really good movie. It's a really, really, really good movie. I love Face Off. I have it physically. It's a great, great popcorn action movie. Love it. Love it, love it, love it. Yeah, I guess. It's such a good movie. It is such a good movie. We are officially in the LBG, right? That's right. I did declare. Tough titties. This was supposed to be a 30-minute live. It's been almost 2 hours. Y'all are so great 2 nights in a row. I really do appreciate you for coming back or for joining if you weren't in the in the live that was 15 minutes before this one. Also very interesting, very thought-provoking. Um, but yeah, this one was just straight tea. Okay, straight tea. And I think it's only gonna pop off from here because like I said, um Future had another lawyer come onto the docket. Just submit their notice to appear. He's already had a lawyer come on to the docket for him and Sony. Um, so I just feel like it's gonna be interesting this week. It's already been really damn interesting, but I think it's gonna continue to be interesting. And I just, again, as we sit with our tea or whatever, preferred beverage or snack that you have going, well, the judge is somewhere. Her staff are in their homes going, my goodness. Well, isn't this interesting? So, oh, I'm so glad. I'm so glad. Oh man, we're just about to end. We're just about to end, but you've got some great replay content. I'm loopy as hell. So I can't remember if you were here last night or not. Okay. Charge it to my head, not my heart. You should watch if you weren't here last night, you should watch last night's live before you watch this present live because they go together. Real bad. They go together. They go together. The earlier main live that we had today was completely different topics. Very interesting as well. But if you're interested in keeping up on what is happening in these cases, which have gone from very sleepy as we were waiting for December to roll around to get people's officials' responses to this lawsuit to, oh shit, it's going down. It's going down. So yes. And this, yep, that's happening on Monday. They've tried everything to postpone it. That ain't gonna happen unless Meg says, Your Honor, we have a problem. But so far, they haven't done that. So, yeah, that's happening. I covered the fact that Spotify has officially wait, was it Spotify? God, I'm gonna confuse them again. No, yeah, it was Spotify has officially been served. So we'll see if they file for an extension of time or if we just plug along to their response at the end of the month. I'm just scanning my email because I've got 1,000 different docket updates in there. I think that's the most pressing. Yeah. Yeah. I know, right? I know. Mm, mm, mm. Thankfully, this trial starts. I mean, I think they're doing. I'm just now remembering now that I'm thinking about it intentionally that I did download something from that docket, I think yesterday or the day before. Their proposed questions for prospective jurors. I think jury selection is happening this week. All the right before trial stuff, I believe, is happening this week or at the end of the week, and then trial is Monday, and it's only supposed to go for a week. And the judge, again, is fiercely holding to timelines. So Milagograms doesn't have shit to really argue, right? When we looked at her witness list and all of that, she didn't have any experts. She didn't have, she had clips of Megan's documentary and her interview with Gayle King. And then, she subpoenaed, what's his name? Joe something. I'm so, my brain is just like, I can't with these motherfuckers. I can't keep them straight. I can't keep the one with the white couch. I can't keep the name straight. I can't keep their biscuit head assery straight. My brain is over it. So she's put him on her witness list. She put one of the Jenners on her witness list. I don't think she ever spoke to any of them about this case. Yeah, all of the depositions. Biscuit Head on Twitch, Livingston, Daystar, yes. Aiden, yes. And all of that is wrapping up this week. So Meg's lawyers are very, very busy this week. They're in court doing whatever pretrial stuff needs to be done. And then they're also finalizing depositions. Like Aiden Ross's, if I recall from the order that I barely remember, but I know I read, his deposition was to be this week as well. So, yeah. Yeah, him. Yeah, him. Oh my God, I might need to do this. I sound so old and black, and you know what? I'm proud of it. Rock Nation! Oh no! Oh no! I'm so sorry. Oh gosh. So yes, all of the things are moving. All of the dockets are moving in one way or another. But this one, boy, this one just came back to life like a bolt from the blue. And we are tapped in and all caught up, which I'm really grateful for because they dumped a bunch of documents last night. I mean, nothing compared to like Comey. But they dumped a bunch of things last night, and then a bunch of things got dumped tonight, and we got through all of them, and I'm so glad about that. We're all caught up for whatever fuckery comes next in either one of these cases. So let's all gird our loins for that day because it's coming, and inevitably on one docket or the other or both, she gonna come back. She gonna come back. So y'all have a wonderful night. Thank you again for 2 nights in a row hanging out with me, sticking with me. If you haven't already, hit the like button on your way out. If you didn't hit it on your way in, hype this live. That would be helpful. I'll probably clip some things out for tomorrow because we started in one place and then we ended somewhere completely different, and I want the content to be real clear for folks who do want to stay in the know about this one. So have a wonderful night. Get some good sleepies, and I will see you very soon. Peace.